Think your property taxes are locked in? Think again. In California, transferring real estate to a trust or LLC the wrong way can trigger a massive property tax reassessment, skyrocketing your property tax bill overnight. My name is Ali Talai, an estate planning and asset protection lawyer who founded Talai Law Offices, and I have seen people lose hundreds of thousands of dollars to the government because they made a simple mistake in the transfer of their real estate. But here's the good news. There are legal ways that let you transfer property without increasing your real property tax bill. In this video, I will break down how to avoid property tax reassessment and keep your low tax rates protected. All right, so let's talk about how property tax reassessment work in California. In California, the law here says the county has the ability to reassess property taxes if there is a change in ownership. It doesn't say that the county can only reassess property taxes when you sell your property or when you purchase a property. Obviously, when you purchase a property, there's a change in ownership, so property taxes get reassessed. However, when you transfer your property as part of the estate plan, as part of the asset protection planning that you're putting together, when you transfer your property from your personal name to the name of your trust, to the name of an LLC, as you could see, this is a change in ownership. The property was under your personal name, and now it's being changed to a name that is not your name, your trust name, or your LLC's name. And so the key factor here is that we're making a change in ownership. And now when we do these sort of plannings, we want to make sure that when the property is transferred, it's done in such a way that there is no reassessment of property taxes. The county has certain exemption that allows a person to transfer their real property without having the property taxes reassessed. Obviously, this only becomes a factor if you have a property that you had for a long time. If you just bought a property, your property taxes are based on the value of the property at the time you purchased. So if you subsequently transfer the property, however, the value of the property is the same, or maybe increase just a little bit, we're not as concerned. However, if you own a property, you've owned this property for many years, your current property taxes most likely is still based on the value of the property at the time you purchased that property. There are some adjustments that the county could make throughout the years, but they're usually very small and they don't make a huge difference in the total taxes that you get to pay to the county for your property taxes. So for you, having the property transferred into a new LLC or a new trust for asset protection planning, estate tax planning, all those things becomes a very important factor. So we got to make sure when you make the transfer, that entity is set up in such a way that property taxes will not reassess. We want to make sure the trust that is set up for you is done in such a way that property taxes will not reassess when it gets transferred to that. And I will tell you right now how we could make sure that will happen. All right, so let's look at a transfer of real estate into a trust. When you set up a trust, and now we're going to make a transfer of your real property into the trust, the county, in order to figure out if they're going to reassess the property taxes or not, if they can reassess or not, they look inside the trust to see who is the current beneficiary of your trust. In any type of trust that you have, revocable or irrevocable, there are three main players or three main roles within your trust. You have the grantor, that's the person who creates the trust. But just to confuse us, there are three other names for the same person that creates the trust: the settlor, the trust maker, the trustor, and the grantor. So anyways, it doesn't matter what your trust uses, what word it uses to refer to the person who creates the trust. You have the person who creates the trust. That's you. Then you have the trustee of the trust. That's the manager of the trust. And again, in most cases, or a lot of time, you're named as the trustee of your own trust. Third position, third role is the beneficiary of the trust. And a lot of times, people just assume that their kids are the beneficiary of the trust. However, in every trust, there are two types of beneficiary. You have a current beneficiary of the trust, and then you have a future beneficiary of the trust. In reality of it, let's say you set up a revocable living trust. Even though you're naming your children as beneficiary of the trust, they're not the present beneficiary. They're the future beneficiary. Both parents would have to pass away, and then they'll become the beneficiary of the trust. So when we create a trust, I said the county, when it comes to seeing if they could reassess property taxes, they look to see who's the present beneficiary of that particular trust. So if you create a trust that you are the current present beneficiary of the trust, which a revocable living trust will be that kind of a trust, and you have a property that you are 100% owner of that particular property, and you transfer the property from your personal name to the name of the trust, because you are also the present beneficiary of the trust, the county will not reassess the property taxes. This would be an exemption because for their purposes, there is no change in ownership. You had 100% ownership in the property got transferred in the trust, that you are the 100% beneficiary of that particular trust. So that would allow you to transfer the property without any reassessment. All right, so now let's talk about a transfer into an LLC. If you own a property in California and you're going to transfer it into an LLC that you own, initially this will fall under the change in ownership, right? Because you currently own the property under your personal name. It's being transferred into this LLC. There's different owners now, and the county can reassess property taxes. However, one of the main exceptions that the county has is as long as the transfer is done in a proportionate ownership, that whoever was the owner of the property is the owner of the LLC, in a transaction that has been done in that fashion, property taxes will not reassess. What do I mean by that? You own the property under your name. You create an LLC. You are 100% member of that LLC. You transfer the property from your personal name to the name of that LLC. You were 100% owner. Before you made the transfer, you made the transfer into that LLC. You're 100% owner of that LLC because you own 100% membership interest of that LLC. That would allow you to make the transfer without the county having the ability to reassess property taxes. One of the mistakes I see more often than I want to see is that clients, a lot of times because they talk to their accountant and their accountant said, maybe we'll give a 1%, 2%, a few percent to your child, to your children, so that you could kick out some of the income that it generates to them, so that that income would be taxed at a lower income tax bracket. That's the goal, but the way they do it is that they create the LLC and it'll say 99% are the parents and then 1% is the child, and then the property's transferred into an LLC like that. That is not a proportionate transfer. And the county will reassess the entire value of the property, not just the 1%. The proportionate transfer says if you own the property 100% under your name, when you make the transfer into that LLC has to be 100% owned by you. So that's the key. That's how you could get the property that you own from your personal name into an LLC without having the property taxes reassessed. Special exclusions available to avoid property tax reassessment. If a parent wants to transfer a personal residence to a child, that transfer could be exempt from any reassessment. And the key here, after Proposition 19, February 16, 2021, there was a whole set of laws that came into effect dealing with property taxes and the transfer between a parent to a child. Two main requirements. One, the exclusion is only up to $1 million. And then also it has to be the primary residence of the parent, and it would have to become the primary residence of the child who's getting it. In that scenario, there is a chance that property taxes won't reassess at all, or maybe only a portion of it would get reassessed if it's above that $1 million limit. The other exemption that we have available is a transfer between a grandparent to a grandchild. However, the nuance here is the parent has to have predeceased the grandparent, meaning that if the parent is alive, grandparents cannot transfer to grandchildren without having the property taxes reassessed. I just shared with you the secret to legally keeping your property taxes low in California. But is the property you're transferring into that LLC actually protected by it? Check out this next video where I answer that exact question of if California LLCs protect your real estate and what you can do about that. See you over there.